You're listening to Systemic Error Podcast. The failure was designed.
Almost all Americans share an embarrassing legal blind spot based on an article by Matthew Ross. The court watchers want a pop quiz. The power is elsewhere. Public confusion is not a scandal. A new study says many Americans cannot consistently apply originalism or living constitutionalism when asked about legal cases, and that legal professionals do better. That is a whole setup. The conclusion some people will try to smuggle in is that ordinary voters are too confused to matter on legal questions. That is a shallow reading. The real point is simpler. Judicial philosophy is mostly elite branding for an institution the public does not control. The people with leverage are the judges and the politicians. The article centers confirmation hearings, nominees and abstract constitutional labels, but actual institutional power sits with the legal class that turns those labels into court decisions. The mass public is not drafting opinions, choosing nominees, or controlling the rules of interpretation. The people who are. So when nearly half of respondents pick not sure, that does not prove democratic incompetence. It proves that most people understand, correctly, that these slogans are underdetermined, professionally coded, and often deployed as political theatre. The framing flatters the system. The weak move here is to treat inconsistency among non-lawyers as evidence of civic failure. That misdirects blame downward toward the public instead of upward, toward a legal culture that packages contested power as neutral principle. Originalism and living constitutionalism are not magic truths. They are arguments used by institutions with unequal power to justify outcomes after the fact. The study's findings may show that legal professionals can keep their stories straighter. They do not show that those stories are more honest or more democratic. Confusion is a feature, not a bug. The confirmation hearing ritual depends on this exact flaw. Politicians ask nominees to perform allegiance to a philosophy that sounds principled but remains elastic enough to conceal what is really at stake: who gets protected, who gets disciplined, and whose rights can be narrowed without saying so plainly. That is why the not sure response matters. It punctures the fantasy that these labels have the stable meaning their users pretend they do. The public's hesitation is not ignorance alone. It is a crude but rational refusal to cosplay certainty around a system built to obscure its own choices. What the study actually reveals. The article wants to measure how well Americans understand judicial philosophy. What it really reveals is how successfully elite legal language has separated power from accountability. The more the court is discussed as if it were a seminar in interpretive theory, the easier it is to hide the political stakes of who gets appointed and what those appointments do. This is the pattern. Institutions manufacture mystique, then blame the public for not speaking the mystique fluently. That is not civic education. It is hierarchy laundering itself through jargon. You've been listening to Systemic Error. Thanks to Alternet for today's article, with the automated voice of Arctic. Thanks for listening.